everyone. Welcome to Legal Tech Hobbyist. I'm Helen. I'm a California lawyer. And lately, I've been exploring how AI is reshaping legal practice, talking to the builders, the founders, and the lawyers who are actually making it happen. So today, I have Ray with me. Ray is a tech lawyer based in Australia. On top of his day job at a global law firm, he built the global AI regulation tracker, over 60,000 users worldwide. He also co-founded Legal Quant with Jimmy, who was on our first episode. So welcome, Ray. Please tell us a little bit about yourself.
Hey, Helen. Thanks for having me on your Legal AI Lab podcast. Thanks for the introduction. I don't have much to add apart from the fact that I also do a lot of coding on the side. I've been coding since high school, and it's been a long-time hobby. And I never really expected law and coding would ever cross over until quite recently, where people have been looking to blockchain and AI throughout university. I did several software engineering gigs as part of during my studies. I worked at a legal tech startup called LawPath, building their document automation platform. And then when I was a paralegal at the firm, I got seconded to IBM to help build their smart legal contract platform. And then after that, I then did the graduate program, became a lawyer, but I've always stayed close to technology. So I was always building on the side. During COVID, when lockdown happened, I like to dance as well, but dances were all canceled. So I thought, I gave myself a project where I'll use AI to analyze my dance moves and compare my dance moves to original dance video and compare how similar they are. And it will tell me in which screenshots where I could improve. And so that was like a dance AI program that I wrote. I made videos about it. It got popular in Asia, especially because I used it to analyze K-pop. It became an app. And since then, that kind of started my social media thing, and then been talking about AI regulations and AI ever since. Yeah.
Well, that's so cool. Thanks, Ray. Thanks for the brief introduction. And let's jump in about the OpenClaw. So many cybersecurity firms are saying don't install OpenClaw. And for lawyers, an AI agent that can access your email, your files, your WhatsApp. So that's pretty scary. So what's your take on this? Will something like this even fall under the EU AI Act?
Yeah. So OpenClaw is one of probably the most visible example of agentic AI. And we're in this new paradigm now of agentic AI, which is a next level from generative AI. So just put in simple terms, when ChatGPT came out 3 years ago, that was the kickstart of generative AI. So AI that used to generate content. So text, images, videos, all of that. And so chatbots are kind of like the front of generative AI. Now we're talking about AI that doesn't just produce text or images, but can actually do things. So, it can open up an app for you. It can browse the web for you. It can send emails. It can transfer money. It can make calls for you. That stuff where there's an action involved, that's what defines agentic AI. And there's been it's quite early stages, but OpenClaw has been the most visible example of that. And now you mentioned the EU AI Act. So, AI regulation is still an evolving space. The European Union was the first to have a comprehensive AI Act, and it regulates all sorts of AI systems. So how it defines AI system is very broad. So it captures most things, and it would capture OpenClaw, but whether OpenClaw is actually subject to the regulatory obligations and rules in AI is a whole different question. I can probably try to simplify this in two points. So first of all, OpenClaw is an open source project, and the EU AI Act does have an exemption for open source, but it's very narrow and it's really only limited to research, right? But for OpenClaw, it's not really in that category, so it will not be saved by the open source exemption. So the next question will be, okay, under what category of rules does it fall under? The EU AI Act has broadly 4 main categories. Category 1 are AI systems that pose unacceptable risk. So these are banned, right? Second category are AI systems that pose high risk. And there's a particular definition for this, but think of any AI that poses safety risks within certain sectors, right? Like health, employment, all that. Then you have AI that doesn't pose these sort of risks, but they need to be made transparent. So for example, chatbots or synthetic data, where it's not obvious that there is an AI behind it, you have to disclose that through labeling or disclosure. And you have another category called general purpose AI models, which are there to cover foundation models, like big, large language models and the like. Now, the thing is that OpenClaw doesn't really fit nicely into any of these categories because it is not just a model, so we can't really put it in the general purpose AI model category, but it's not categorically a higher risk system. And let me explain, because this is a general purpose tool. You can apply it for very harmless use cases, for example, browsing the web, all the way to very high risk cases like managing your bank accounts, right? That one tool can be applied to both ends. The EU AI Act doesn't discriminate agentic AI as a particular regulated entity. It depends on how you use OpenClaw for. So there can be some cases where it is caught by the high risk rules. In other cases, it's not, simply because of how you use it. And that basically the conclusion is that AI regulation used to be very much focused on use case, but now we'll probably have to think about another way to look at this, where actually there could be things where it is inherently risky and you have to account for that.
That's really interesting. So basically, what you're saying is the current rules were designed for specific use cases, like high-scale AI, recruitment AI, but OpenClaw doesn't fit any of those because it can do everything. So that's what makes it so tricky. So that's the regulatory side. But what do you actually do about it? If a lawyer wants to try AI agent, where does a kind of responsible deployment look like?
Yeah, so there are many practical ways to safeguard risks. And so when I talk about risks, I really mean the security risks. So, letting an agent access your bank account, access your sensitive data, the risk is where, let's say it accidentally leaks that information onto the internet and others can see it. That's a very simple example where risk can materialize. So we want to be able to control that, right? And there are three main quick tips you can do it. So number one is to put an agent in a sandbox. So when you run OpenClaw, you can choose to run it within a virtual environment where it doesn't, where all your core sensitive data is not in that environment. It's outside of it. And inside environment, you can let it play around, do whatever, but it will be constrained. So it's basically put it inside a prison. It can never leave that prison, and as long as the prison itself, there's nothing sensitive in there. That's one way to keep it safe. Another way is to control permissions. You can specify whether it can access your emails, access your accounts, access your chat messages. You can choose to tell it whether to do it or not. So that's another way to control that. And third is authentication. Every time you want the agent to access, let's say, your emails, you want it to verify that it is your account and also verify that it's coming from your computer rather than someone else's computer. This is so that people don't intercept it and try to basically take on your identity and use your agent to do things for you that you don't want. Yeah.
Yeah. So, okay, that makes a lot of sense. So, if I understand correctly, it's three layers: the sandbox, the limit access, and then you need to authentication. And I also want to mention the reality check. So, actually, there's no magic solution, and the principle is that if you want the power, you have to accept the trade-off.